One NCP leader is saying that polygamy is acceptable. It should be out there. And the problematic part is not just this preaching of polygamy, but also how it is being compared that it is implemented in Pakistan. And the furthermore sad thing is that it is coming from a female. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to talk about an erupted discussion from Maharashtra Assembly which talks about polygamy, which has revived discussions that where are religious rights, where are women's rights placed, where are the fundamental rights and so much more. So first let us understand that what exactly has been said by NCP leader Sarla Mudgal. So she basically said that polygamy is an acceptable practice in Islam and it is also mentioned in Quran. That is why nobody should have a problem with that. Now this being said, there was also a parallel comparison with presence of this practice in Pakistan, how it is present there, implemented there, then why not in India? Now, even though there are certain parallels which are not understandable and could be a personal opinion here, but a person who has a voice, who can state such views to a larger audience, this is something that needs to be dissected and understood. So, when we are looking at this whole situation, as I said, this has been a discussion by a female MLA and she has been defending polygamy. She has stated that it is permitted under Islam, Muslim personal law and also mentioned in Quran. Now on this note, the first thing that we need to discuss is polygamy allowed in India? We have to talk about our country. Is polygamy allowed in our country? So for this, first thing that you need to understand that in our country, the religious practices are guided by personal religious laws. So to understand this better, let us bifurcate this. So if we are looking at polygamy itself and if we are looking at it for the community of Hindus, it is prohibited because this is monitored through personal religious law here. If we are looking at for Christians, it is again prohibited. For Parsis, prohibited. But for Muslims, it is permitted. Polygamy up to 4 wives based on the Shariat law is permitted for this very community. But all of this comes from where? It comes from that all of these religions are under separate personal religious laws. So this clearly shows that India follows a plural personal law system where marriage and family matters are governed by religion specific law. So as of now, it's clearly polygamy is not banned, but the religion specific laws of certain religion do not permit it. And when we are looking to understand this better, we have to start from scratch and look at the constitutional basis first, and then probably we can move also into certain Supreme Court judgments that have come up. This is the legal fundamental basis. There is no uniform law across the country. And what can be the answer to this? Do you think UCC can be the answer to this? We will be moving to that also. Now looking into constitutional basis. Now let us talk about the first article, that is Article 14, which talks about equality before law. That means there is guaranteed equality before law and also equal protection of laws. And it is clearly understood based on this article itself that if we are allowing only Muslim men to have multiple spouses, that creates gender inequality. It violates the equal treatment of women. Furthermore, this is exactly where we need to see that how law is protecting males but not females. And then we come to Article 15, which talks about non-discrimination. That means prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. When we are looking at this and if we are creating gender-based differences in marriage based on personal laws, it's not something that is compatible with this fundamental right. Now this part of it puts this practice into very much question and debate. But when we look at Article 25, it talks about freedom of religion. How? Constitution guarantees that there will be freedom of conscience, the right to profess, practice and propagate religion. That means religion is something that will be individualistic, it will be personal. But at the same time, we have to remember Article 25 is not absolute. And state has the right to regulate activities associated with religion. The state can enact laws for social reforms, because if we are talking about social reforms and if state would not interfere, then sati pratha would still be going on in our country. Therefore, what we can understand from constitutional basis, that if a religious practice needs to be regulated, it can be done by the state if it is violating the constitutional principles. And to understand this better, this is not something I am saying, this is also what has been emphasized by multiple Supreme Court judgments. For example, Sarla Mudgal Case, 1995. Now, this is where it was clearly stated that conversion to Islam cannot be used to contract a second marriage. That means if somebody is going for having multiple marriages, they cannot just convert to Islam and use the Shariat law for their protection. Second marriage amounts to bigamy. In this, if the person is of different religion, this will be counted as bigamy. Lily Thomas case of 2000. In this, it was reaffirmed that what was said in this judgment holds true, holds the stand. Apart from that, we also have multiple judgments which clearly say that polygamy, which is a practice which is being associated with Islam, which is being associated with Quran, it is not an essential religious practice. Shayara Bano case, one of the most famous cases when we are talking, it highlighted that how there are unconstitutional things going on in our country. Even though they are concentrated in any religion, they can be declared unconstitutional and they can be stopped dead in tracks, they can be prohibited, such as triple talaq. And this is where we get to see that it is the role of state, it is the role of judiciary to reinforce the not just gender justice principles but also the principles of our constitution itself. And this is exactly where the question arises of the common civil code, uniform civil code, something that is as controversial and as much debated as we are looking towards such practice. And when we are talking about this very state in which assembly, this statement was made, that state itself is considering a uniform civil code. They already have a panel drafting the bill. The sentiments in this very assembly look positive, and probably we can connect these statements coming to the timing of UCC being mentioned in Maharashtra. So this is where I would like to ask you, do you think UCC should be brought in to address the principles, ensure the principles of constitution, or should the personal religious laws be given space without considering what such practices as polygamy and triple talaq are doing to our society? In this very context, when we are speaking of uniform civil code itself, as of now in our country we have already 3 states practicing uniform civil code. States have brought in and implemented that. We have Uttarakhand, we have Gujarat, and we have Assam. And now when Maharashtra government is considering it and putting it on table, it seems like this is the answer to hold on to the non-essential religious practices which are probably harming the society. But at the same time, UCC is not the panache for everything. It is something that comes with the positive but as well as the negatives. So let us understand a little bit more about Uniform Civil Code, because it seeks to replace the religion-based personal laws with a common set of civil laws applicable to all citizens. The areas such as marriage, divorce, adoption, guardianship, maintenance, inheritance, succession will all be covered under this common set of laws applicable to all religions. And it does not interfere with religious belief, rituals or models of worship, but it administers these broader civil laws. And it definitely favors gender justice, equality before law, national integration, simplification of laws. But at the same time, there are worries about religious freedom concerns. There are worries about minority rights. What about the diversity of India, and what about tribal customary laws? So as of now, in context with what Sana Malik said, it seems like that this is a gavel that is banged on gender justice rights, which is not fair, and UCC being tabled at the very same time is pointing into a direction that calls for more discussion. What are your thoughts on this? We have understood all the dimensions around it. Let me know what do you think? Do you think UCC is the way to go? Do you think that religious personal law should have the space? What are your thoughts about this? Let me know in the comment section. I'll be leaving you here with a prelims practice question. I'll be leaving you here with the prelims practice question. Let me know the answer to this in the comment section. That was all from my side. Thank you so much.